One of the most important areas of our law practice is the one most people put off until it's too late: wills and estates. It's almost that clients are afraid to even discuss the possibility of dying and what to do with their estate. This is Charles Monster, and welcome to the Wills Trusts Bootcamp. In this short video, I'll give you critical steps to protect yourself, family, and assets. To put my comments in perspective, I've been representing clients with wills and estate issues for over 30 years. I'm the founder of the Monstercraft Law Firm with 8 offices throughout the state of Texas. As I do in these bootcamp presentations, I will distill the critical information you need to know about wills and estates to 3 points of a simple triangle. The apex of the triangle is what happens to you if you die without a will in place, which is known as intestacy. Now that sounds like a complicated legal term, and it really isn't. Intestacy simply means you die without a will, and the state of Texas, not you, decides where your assets go, and it could even go to your ex-spouse, which may not be appreciated by your current spouse. Unfortunately, most people fall into this category of being intestate because they fail to prepare a simple will. The second angle is preparation of the will in the probate process. And the third and final angle of our triangle are special needs or issues which come up in the estate area, including the preparation of special provisions of minor children and those with disabilities. Guardianship is a complex issue which also arises within our practice. Well, let's start with intestacy, which we just talked about. And it's a common situation where somebody dies without a will. This can be highly problematic in Texas because the state will decide what happens to your assets and loved ones in the absence of your instructions. The distribution of assets in an intestate situation when you don't have a will depends on how your assets are categorized, whether they're community property or separate property under Texas law. If community property, your surviving spouse will inherit all community property if all of your children are the children of the surviving spouse. That's important. If not, 1/2 goes to your surviving spouse and 1/2 to the surviving children of your prior spouse. As you can see, your assets can end up potentially in the wrong hands if you don't have a will in place. Now, if you have separate property, which is typically property you acquired before marriage, your surviving spouse receives just 1/3, with a balance going to your children. If your parents or siblings are still alive, well, the distribution becomes even more complicated. Bottom line, you cannot effectively protect your spouse and family without preparing a formal will. Specialty trusts can also be set up to protect the interests of family members or third parties. These trusts or instruments are highly specialized and even provide for the financial needs of minor children in the event of your death. Critically, the language and terms of the trust are essential and must comply with the requirements under Texas law to protect you and your assets from creditors. The person or persons benefited by the trust are known as the beneficiaries. A third party or sometimes an institution is appointed to administer the trust once you pass, and it's known as an executor. Trusts are a great tool for estate planning and can be simple or complex. I highly recommend that you consult an estate attorney with experience and never draft these documents on your own. You also have to be apprised of tax planning, which is a critical element. The second point on the triangle is the preparation of a Texas will and knowledge of the probate process once you're gone. The preparation of a will is not complex in Texas. You must be at least 18 years of age, of sound mind, and execute the will in the presence of at least 2 witnesses who must also sign. Failure to follow these simple steps can be fatal to the validity and enforcement of your will. Although the steps are simple, we recommend that an experienced law firm draft the will, as mistakes can easily occur which will upset your estate plan, create complexity and costs. A lawyer will make sure that the will specifies who will receive your assets and the conditions for such bequest. Typically, confusion arises when clients draft their own documents, which leads to conflict between the surviving spouse and children. It is not unusual for the affected parties to lawyer up, which is not only emotionally upsetting but costly. Another issue relates to a decision to disinherit specific parties or limit the nature and timing of property received, typically if a minor is concerned. Again, an experienced lawyer can easily handle these provisions and make them enforceable. The probate process can typically be avoided altogether when you're dealing with small or a limited estate. Texas affords the surviving family a simplified process known as muniment of title. and it deals with a small estate recognized by all of the probate courts in the state of Texas. They all know about it. And if probate is necessary beyond a small estate, which can be handled with immuniment of title, then proper planning and drafting can still streamline the process and benefit everybody involved. Critically, certain assets avoid probate altogether. I'm sure you've heard about that. Avoiding probate typically relates to insurance policies and bank accounts, assuming, and this is important, the surviving parties are properly named as beneficiaries. The third and final angle of our triangle deals with what I call special needs and issues, which often come up. Typical issues relate to the protection of third parties, including minors and those with special health or mental issues. A properly drafted will includes what are known as testamentary trust provisions, which are essentially trusts operating within the confines of the will itself. In a common situation, the will provides for the care and education of minor children in the event you die and your spouse dies. Well, what's going to happen to your kids? That's what the testamentary trust is all about within the confines of your actual will. There are complex provisions which provide specific instructions for the care of your children. Do not leave them to inexperience and chance. Do not draft, repeat, do not draft these provisions yourself and consult an experienced attorney. A critical process which requires legal assistance is known as guardianship, where the court supervises the care of persons in need who are often vulnerable, including abused children, infirm or mentally challenged adults, and the elderly, and others. The guardian is appointed by the court for the supervision of the affected party, who is known as a ward. This is a highly regulated process, as you would expect it would be, and necessitates the involvement of experienced counsel. And that is a brief introduction to the world of wills and trusts. At Mastercraft, we're here to answer your legal questions about estate planning, drafting a will, and other issues which come up. Feel free to give us a call at any of our 8 offices across Texas. This is Charles Mosser speaking and wishing you prosperity in all things. Thanks for joining us.